it's Guy DiMartino. I am a Northwest Indiana estate planning and probate lawyer, and today I'd like to talk a little bit about qualified retirement funds and your estate plan. But before we get started, let me just remind you that if you have any questions about a Northwest Indiana estate planning or probate matter, you can always reach out to me at indianaestatemeeting.com. We can set up an appointment and go over your questions or concerns regarding your estate plan or somebody in your family estate plan. So years ago, with qualified plans, whether it be usually a rollover IRA would be the most common qualified plan, you know, you were able to stretch out the distributions after somebody's death for a long time. And just last year we came and we had to deal with a new act that came out called the Secure Act, and for most people a payout has to be over 10 years. But today I'd like to talk a little bit about something different, and it's regarding a qualified account, and that is this. I was recently speaking with somebody who is single, and he or she wanted to leave their stuff to beneficiaries who were family members but not really close family members. This person did not have any living children anymore, any living grandchildren, and so the closest people that were left were siblings or stepchildren. And this person had a qualified fund. And you know, a qualified fund is a tax-deferred fund. And so the whole idea is you put in money that's pre-tax money, it builds up over the time, and then as you take your minimum distributions, or you take your money as you get older, the odds are that your income is going to be less, so your tax rate on the money is going to be less. So this person wanted to set up a trust, and then all the stuff would go into the trust, and then some folks in the trust would get specific bequests of money, and other folks would be the residuary beneficiaries, and these residuary beneficiaries would go ahead and get a percentage of the stuff. But this is the rub, or this is the issue that we have to look at in planning for a single person with qualified plans. If the qualified plan goes into the trust and the trust is the beneficiary of the qualified plan, trusts are taxed at a higher rate. So how do you handle this tax problem? Likewise, if the person were to liquidate his qualified fund, his IRA or her IRA, then they would have to pay tax right now, or you could go ahead and step it up and every year take out so much money from the qualified fund and put it into a tax-based fund. But generally speaking, for the individual, the tax rate most of the time is a lot less than for an entity like a trust. So these are issues that really need to be discussed when you're putting together your estate plan. You need to discuss this with your estate planning lawyer, with your financial advisor, and with your accountant, so you have a true understanding of what the tax consequences are to your qualified funds. And this is especially true if, number one, you do not have a spouse, or number two, you're trying to protect your spouse through an asset protection plan. If you have any questions about a Northwest Indiana estate planning matter, you can always reach out to me. I am Guy DiMartino. Have yourself a great day.